dignitaries are arriving. Please put your hands together to welcome on stage Hon'ble Sri Justice R. Basant, former Judge High Court of Kerala and Senior Advocate Supreme Court of India, and Hon'ble Srimati Justice Anu Sivaraman, Judge High Court of Karnataka and President Karnataka Judicial Academy. Good morning, everybody. It is an honor to welcome you all to the Karnataka Judicial Academy's 5th lecture in the Silver Jubilee Lecture Series, a distinguished event that celebrates wisdom, ethics, and the enduring values of the judiciary. This morning, we have gathered to reflect on fundamental principles of criminal jurisprudence, the doctrine of proof beyond reasonable doubt. This doctrine is the cornerstone of our legal system and ensures that justice is delivered with all fairness. To formally begin the event, may I request Srimati H.R. Radha, Director, Karnataka Judicial Academy, to kindly deliver the welcome address.
Honorable Srimati Justice Anu Sivaraman, Judge High Court of Karnataka and President of Karnataka Judicial Academy. Honorable Sri Justice R. Basant, former Judge High Court of Kerala and Senior Advocate Supreme Court of India. Honorable Srimati M.G. Uma, Judge High Court of Karnataka. The Registrars of the High Court of Karnataka, esteemed resource persons of Karnataka Judicial Academy, respected judicial officers, distinguished invitees, ladies and gentlemen, good morning to all. It's another day to excel as we come together for the 5th lecture in the Karnataka Judicial Academy's Silver Jubilee Lecture Series. And I feel privileged to extend a warm and heartfelt welcome to each one of you. We are fortunate to have a rare legal luminary, Honorable Sri Justice R. Basant, on this occasion. Today, if the members of the district judiciary across the country can think of purchasing their dream cars, buy sites, build own homes, and send their children abroad for higher education, etc., without any fear or hesitation, it's because of the active and benevolent role of Sri Justice R. Basant as a member of 2nd National Judicial Pay Commission. Sir, for the substantial increase in pay and all other benefits the SNJPC has bestowed on us, we're deeply indebted to you and other members of the Pay Commission. The pro bono assistance of Honorable Sri Justice R. Basant as a member of SNJPC is not a standalone event. His Lordship recently, having acted as an amicus curiae in a long-drawn family dispute, turned down the fee of rupees 45 lakhs, and that stands out in the present day situation when everybody wants to practice law for earning money. We are indeed grateful to our Honorable President for giving us such an opportunity to express our gratitude in person to Honorable Sri Justice R. Basant, who started his legal career at Kozhikode in 1973 as a junior of Sri K. Bhaskaran Nair, a noted lawyer on criminal side. Justice R. Basant was recruited as a district judge in the year 1988 and later elevated as the judge of Kerala High Court. His grasp of law is evident from the judgments, to mention a few. Rohit S. Ved versus State of Kerala, where dealing with the question as to whether a person facing allegations in a prosecution under Section 138 of NI Act and against whom a warrant of arrest, bailable or non-bailable, has been issued, can appear before magistrate through counsel and claim exemption under section 205 CRPC and plead guilty. Balancing the rights of the complainant and the rights of the accused, His Lordship held that both summons and warrants are only to secure the presence of the summonee or the warrantee, as the case may be, where the personal presence of such summonee warrantee is not necessary for the progress of the case, and he can be exempted from personal appearance before the court. There can be no reason to ritualistically insist on the presence of the summonee or the warrantee to facilitate consideration of the application for exemption. All summons cases and all other cases where summons is issued at the first instance under section 204 CRPC shall fall within the sweep of section 205 CRPC. In such a case where the court is satisfied that there is reason to grant exemption under section 205 CRPC, the fact that a warrant has been issued later is no reason to insist on the personal presence of the indictee to consider the application for exemption, whether to plead guilty or not. In Soumya and Thomas versus Union of India, it's a matter arising from a family court's order challenging stipulation of 2 years period as the minimum mandatory period for separate residence under section 10A1 of the Divorce Act. The provision was read down as unconstitutional, and it was the period of 2 years was read down as 1 year. And all the high courts, as per the provisions of Constitution, are bound to follow this. And in fact, this has greatly benefited the parties who are at loggerheads in such situations. Moideen Kuti versus State of Kerala is another instance where His Lordship had an occasion to deal with the question as to whether a defaulter can be sentenced to undergo rigorous imprisonment under section 125(3) CRPC for non-payment of maintenance. And does the expression imprisonment under section 125 subsection 3 CRPC take within its sweep rigorous imprisonment also? Dealing with this question, His Lordship has held that the expression imprisonment under section 125 subsection 3 CRPC must receive a more liberal and humane interpretation consistent with the constitutional ideas as to avoid the consequences of subjecting such a defaulter to the ordeal of rendering involuntary hard labor for the mere indiscretion of failure or refusal to make payment of the maintenance amount. Lastly, there are several judgments, but I have noted down only 4 of them. This one deals with the plight of labor. M. Nujumuddin versus the City Police Commissioner and others. The question involved was whether a head load worker without registration under the relevant rules of Kerala head load worker rules entitled to work, is an employer entitled to employ them? What, if any, is the consequences of non-registration in such an area where the scheme is not functional? And while just talking in the VIP lounge, His Lordship was mentioning, if you choose to rest and rust, you have nothing to look forward to and wait for. Therefore, after laying down the office, he has been practicing in the Supreme Court of India as a senior advocate, and he combines the rich experience of the bar and the bench in right measure while addressing various legal issues. Sir, we are truly honored and blessed to have you with us, and look forward to an igniting session on the ever-intriguing topic, the doctrine of proof beyond reasonable doubt. I, on behalf of Karnataka Judicial Academy and everyone present here, extend the warmest welcome to you, Honorable Shri Justice R. Basant, and request Honorable Srimati Justice Anu Shivaraman, Judge High Court of Karnataka and President of Karnataka Judicial Academy, to offer a book as a token of our respect. Thank you, ma'am. It would not be an exaggeration to say that Madam is the lifeline of the Academy. Under Madam's able leadership, we continue to excel in the field of judicial learning, and her leadership has been a constant source of support and inspiration for us. I, on behalf of everyone present here, extend a heartfelt welcome to Honorable Srimati Justice Anu Shivaraman and request Sri Narayan Prasad, Additional Director of Karnataka Judicial Academy, to offer a token of our affection on this occasion. Honorable Srimati Justice M.G. Uma, Judge High Court of Karnataka, has graced the occasion. I extend a warm welcome to ma'am. I cordially welcome our esteemed resource persons, without whose support we virtually cannot function. All the Registrar of the High Court, Srimati Prabhavati M. Hiremat, Principal Judge Family Court, Bangalore; Srimati K.B. Geeta, Principal District and Sessions Judge, Bangalore Rural District; Shri B. Muralidhar Pai, City Civil and Principal City Civil and Sessions Judge, Bengaluru; Shri M.L. Raghunath, Member Secretary, KSLSA; Shri J.N. Subramania, Chief Judge, Court of Small Causes; Shri Dinesh Hegde, Director, Arbitration Center; all the respected judicial officers, the trainee judicial officers of 2024 batch, the faculty and the staff of Karnataka Judicial Academy, students from Law College, and members of press and electronic media, and all those who are watching us live on our YouTube channel. I once again extend my heartfelt welcome to all of you. Thank you.
Thank you, madam. On behalf of everyone, I extend a warm welcome to you also, madam. May I now request Hon'ble Srimati Justice Anu Shivaraman, Judge High Court of Karnataka and President Karnataka Judicial Academy, and I also request Director and Additional Director of our Academy to felicitate Hon'ble Sri Justice R. Basant. Thank you, leadership, for felicitating today's speaker. We now arrive at the highlight of this morning, the 5th Silver Jubilee Lecture. Honorable Sri Justice R. Basant is an eminent legal expert known for his profound knowledge and insightful analysis of criminal law. May I request His Lordship to deliver the 5th lecture in the KJA Silver Jubilee Lecture Series on the Doctrine of Proof Beyond Reasonable Doubt. Please, my Lord.
respected President of the Karnataka Judicial Academy, Justice Anu Shivaram, Honorable Judge who is present today, Madam, ladies and gentlemen. It gives me great pleasure to be invited to make a Jubilee lecture at the Karnataka Judicial Academy. As I have been introduced, you know that I basically belong to Kerala, and I come from the Kerala High Court. Kerala High Court also has a Kerala Judicial Academy. The forerunner of the Kerala Judicial Academy was a directorate of training which was established in Kerala, one of the pioneer attempts made in judicial education in the Union of India. And I think we owe it immensely to Justice Malimat, our Chief Justice at that time, that they embarked on such an experiment which was forerunner, an eye-opener to the judiciary in India. I recall with gratitude what Justice Malimat did for the Kerala judiciary during those days. I also, with great pleasure, recall the towering personalities of the Kerala High Court at that time, like Justice U.L. Butt. You know, I've been told that he comes here very often. He used to come here very often. Justice K.T. Thomas, who later on became the judge of the Supreme Court of India. Justice K.S. Paripurnan, and also Justice V. Shivaraman Nair. They constituted the initial board of the Kerala Directorate of Training. Now, I thought usually I start by saying, let me know my audience, the target group, or shall I call them the victim group? No. So that I always say, let me know who you are so that I calibrate the level at which I must speak to you. I was doing that because it's such a big hall, like I can't try to do that. I've been informed that there's a group of persons who have been dealing with the criminal justice administration matters in abundance. I'm also told that the future of the Karnataka judiciary, Indian judiciary, is also there as young inductees over here. I'm very happy to see that also. In you lie the future of the entire system, which I may, at times I say, is at the crossroads. It's for you, for a younger generation, to lead it out of that and to get it to safer places where the old glory would be redeemed. I'm an old man, sometimes I glorify the past. Excuse me for doing that, but I'm sure the future generation will come to do that. I also think I owe the credentials. You know, you're all people dealing with evidence under 45. You're likely to ask me, what is your credentials? How are you competent to come and speak to us? I may say the only competence that I can claim is, I have, as they say, donkey's years of experience with the system. I count my experience from the 3 years in the law college, which I think is the most valuable experience that I have started my interactions with the system. Another 15 long years as a practitioner at the grassroots level, where occasionally, once or twice, you may have gone to the High Court, but basically I was a practitioner at the grassroots level. And then I say, sometimes people say at the lower court, then say, how low? they ask me, and I say, the lowest of the lowest, if I can claim it so. I have appeared before the third-class magistrate. It's a rarity. You don't see them now. After the 1973 code, you don't see a third-class magistrate at all. I've seen a third-class magistrate, not only a third-class magistrate, an honorary third-class magistrate, before whom also I've appeared. Those 15 years, I think when I stand in the Supreme Court today, I find many of people around me, this side and that side, are blissfully unaware of what is happening in the trial courts. And therefore, I deem it a great, valuable experience that I have 15 years of practice at the lower levels of the judiciary. The next 10 years, I had the privilege to be a member of the higher judiciary in Kerala, which I really enjoyed. And after that, as somebody said, I chose not to rest and rust. I thought I will go to the Supreme Court, where I think, I keep repeating this, I think young High Court judges would like to know this. Your post-retirement practice is not for anything else. If you could prove something, you should have proved it by now. You can't try to prove anything more at that point of time. But enjoyably occupied. That I think I always coin this expression and say, the post-retirement engagements are primarily meant for enjoyable occupation, and which I'm getting in rich measure now. I'm enjoyably occupied for the last 12 years of my life as a senior counsel in the Supreme Court. This is my introduction to you. Under 45, any one of you wants to stand up there and ask me, what are your credentials? I've given you that. So it works out to a total of 55 years in the system. I think it's pretty long. Well, all these years, I found myself gravitating to the criminal side of the work. So they call me a criminal advocate, a criminal judge, like that. Well, I'll straight away come to the topic that we have. It's important for all functionaries in the system. We are all functionaries in the system. Be you a magistrate, be you a district judge, be you a high court judge, be you a lawyer at the grassroots level, high court or the Supreme Court. We are all functionaries under the criminal justice administration system. I'll come to system a little later. So it's important that we have a comprehension of what is the system. What is the function of the system? The macro system has functions. We are relevant to the polity. How are you relevant to the polity? What function is the macro system trying to administer into the system, to the polity? That's important. Then you consider, I am a microchip in the macro system. What is my role as a microchip? When you try to do this, I think it's very, very important that you have a clear comprehension of what the system has to achieve. What is it that the criminal justice administration system has to achieve? If I were in a class, I would have asked you questions. I would have asked you, what do you think is the system? Some people tell me it is the punishment of the guilty. Some others tell me it is the exoneration of the innocent. Some others tell me that it is reformation of a fallen person. You can have multiple choices. But I believe the purpose of the system is none of these. This is not the purpose of the system. Students of political science would know, why is a state constituted? Why is a state constituted at all? As a citizen, I pay taxes to the government, to the system. I abide by the laws even when I think the laws are unjust, but I abide by the law. Why do I do that? Why is the state constituted? I believe primarily the state has two inalienable functions. We have taken many other functions also, but primarily the state has two inalienable functions. One is protect me against external aggression. Maintain your army, maintain your nuclear arsenal, but ensure that I am not disturbed by external aggression. The second one, perhaps according to me, most crucial in the normal living period, is that protect me from internal disturbances. Ensure that I am protected. We constitute a state so that the state ensures that protection to the ordinary citizens. Freedom from crime. When I say internal disturbances, I am referring to that. Protect me from crime. Not only crime, but the threat of crime also. Sometimes in your whole life you may not have had occasion to suffer because of crime, but you suffer under the fear of crime. So that the system's, one of the fundamental requirements is Protect me against crime, protect me against the threat of crime. That is one important function, or may I call it the function, which the criminal justice system has got to achieve. There is yet another new dimension in the modern republics. In a country like India, where the Constitution guarantees to you a right to life, it is the duty of the state to ensure that I am protected, my right to life is protected. And protection of the right to life does not mean mere existence. It must also protect my right to live a full life. If I have to live under the fear of crime, I am never able to blossom into my fullness. So criminal justice system, in a way, has to ensure that Article 21 rights, right to life, is also protected. So I would think that you and I are functionaries, small cogs in the big wheel, which try to ensure these two things. That is, protect people from internal disturbance, which I say crime. Second is, ensure that your right to life is meaningful in that I live without being a victim of crime, without being a victim of the threat of crime. Both are very, very important according to me. So, it's the duty of every modern state to run a criminal justice system, to which we all belong, I repeat, so that these two fundamental requirements are satisfied. That is what you and I, as member of the system, tries to achieve through the system. Well, once we are sure of what is to be done, I would always call it the challenge before the modern criminal justice administration system is to have a crime-free state. You may call me utopian. So long as human beings are there, you will never be free from crime. But that doesn't militate against the object, the dream, the ideal. Maybe utopian, but the ideal is that I must have the right to live in a crime-free state. So understand it very clearly. Do not lower yourself down to one adjudicating guilt and exoneration of reforming your larger purpose. It is only when you understand the larger purpose for which we are all functioning that you are really able to apply yourself to the task before you. The task before you, I assert, is that we must try to develop a crime-free state where the message will go loud and clear that crime shall not pay. Crime will be visited by punishment. This is the message which we have to send round. This is why the system is keeping us all in the system. SNJPC recommended a lot of benefits for you and you're all enjoying the benefits, I've been told. But why does a poor country invest so much on its justice system? It is, the brief to us is, ensure that you have a crime-free state where people will be deterred from committing the crime. This is the brief for us. Let's understand it very clearly. It's not to get monthly salary and then enjoy, send children abroad, go in the best of cars that are available. No, these are all incidental. But the primary function that we have to achieve for the polity, if you have a commitment to the polity which is in a poor country which is maintaining you so high, you must always realize the accountability. And understand that we belong to a system whose brief is to ensure that we have a crime-free state. Ideally. I know it's never practically achieved. If that is achieved, all of us will be dismissed. We'll become irrelevant. Now, to do that, I go to my next point. What is the best way to deter people from committing the crime? Please tell me, how do you deter people from committing the crime? I know that the Nirbhaya case came, and immediately we amended all the laws to say the criminal will be hanged, he will be done this, that, everything. I call it a knee-jerk reaction. Increasing the punishment is only a knee-jerk reaction to a very bad situation that is on hand. You say that every rapist will be punished with death. Judges will be more careful before finding a person guilty, and your defense systems will work, and lesser number of people will be convicted, and greater will be the enthusiasm and encouragement for people to commit the crime. So that increasing the severity of punishment is a very, very unprofessional way of looking at prevention of crime, according to me. How do we prevent crimes then? Tell me. How do we try to prevent crimes? I would think we must have a system where the message will go loud and clear that every criminal will be punished. Technicalities of the law notwithstanding, we must be able to ensure that every criminal is punished. That is the best way to deter people from committing the crime, not increasing the punishment of that one person who is caught. He may be hanged. I will always say about, I think my time is limited, but severity of punishment when I speak about, I've heard of a story where England there was a lot of pickpocketing going on. Right? A lot of pickpocketing going on. The amateurs got together and decided, hereafter we shall impose the punishment of death on those who pick pockets. Very good. Everyone thought everything was fair. Then they found, even then picking the pockets were continuing. Then they decided that we will have a public hanging of the people, so that the message will go loud and clear that, no, picking the pockets, you will get this. And so, thank you very much. Thank you.
Want to sit and address?
No, that's it. I'm not that old. Thank you. No, and they say a lawyer is always on his elements always when he stands up, not when he sits down. The judge may be otherwise, but the lawyer is that. And I claim to the constituency of the bar, and having served a deputation at the bench, I have come back to my constituency. And therefore, I continue to identify myself as a lawyer. Thank you. I was telling about this public hanging. And then there came the day, there was a public hanging, people were all watching, and the public hanging was going on. Everyone was so traumatized seeing that. But when people started going home, they found their several pockets picked. So, severity of punishment, according to me, is not. Most criminals commit the crime thinking that they will not be caught. Most criminals commit the crime thinking that at the end of the day, something will come that I will not have to face the punishment. So I keep repeating this. More criminals can be deterred from committing a crime by effectively communicating to them that if you commit a crime, you will be caught and punished. I call it the dimension of certainty of punishment. Crime will be visited by a punishment is something that we have to ensure. Right? That's the best way. And next is, rather than convey to them that you may be hanged years later, it will be much better to communicate to them, if you commit a crime, you will be caught and you will be sent to prison immediately. Well, certainty and immediateness or expediency of the punishment serves as a much, much better deterrent than the severity of punishment. Why am I telling you all this? Your brief as microchips in the system is certainly to ensure these two. We have been lulled into the complacency that there's no harm if you open the gates of prison and let out 1,000 persons, but let not one person from outside be dragged in. Both are important. Both are very, very important. One cannot be sacrificed at the altar of the other. And therefore we all have to understand that as administrators of the criminal justice system, it is up to us to ensure these two things. Certainty of punishment, and the next is immediateness. When I say immediateness, I am not saying that in some of the Middle East countries you commit crime, from there you are dragged to the police station, from there you are dragged to the court, and thereafter you are punished. I am not saying that. Subject to the principles of natural justice and reasonable opportunity, which our system is wedded to, you have got to ensure that expediency is there. So may I tell you now, to start our discussions, your brief is a crime-free state, for which the method to achieve that is by ensuring that the criminal is deterred from committing a crime. And the best deterrent that we can afford to the polity is the deterrence by saying that you will not escape on technicalities. If you commit a crime, you will be caught. And if you do that, you will immediately be brought to punishment also. Immediately subject to quote unquote. Immediately does not mean the type of justice administration which we find in some other countries. I'm not enamored by that. Subject to the laws or the procedural safeguards of reasonable opportunity, the right to be heard, etc., etc. I think this you have to ensure. That is my duty. We then come to the next aspect of the discussion as to what is proof? What is the burden of proof? The subject, if you read the literature on it, the Anglo-Saxon period onwards, this discussion has been going on as to what is the burden of proof in a criminal case, what is the concept of proof beyond doubt, what is the concept of proof beyond reasonable doubt, what is the concept of proof beyond any reasonable doubt or a shadow of a doubt. All these, we'll come to. It's a topic that has been going on and on and on. One Mr. Basant coming and discussing is not going to end the problem, I'm fully aware of. We'll have to see what it is. As I said, this is a class, I would have asked somebody, what is the burden of proof in a civil case and a criminal case? And pat would come the reply, without any doubt, that in a civil case it is enough if you establish your case by a preponderance of possibility, whereas in a criminal case you have to establish it beyond doubt. I will now only say you have to establish it beyond doubt. Other things I'll come to later. How did this distinction come? Has any one of you thought about it? How did this distinction come between proof by preponderance of possibility, probability, and the proof beyond reasonable doubt, beyond reasonable doubt? How did this distinction come? It's very important. We have got to understand the principles clearly. You will find, if you are in difficulty, you always go to a statute to find out, isn't it? What does the expression proof or proved mean? Can any one of you tell me? Under which statute do I look for? Under which general law do I look for to find out what do you mean by proof beyond doubt or proof by preponderance of possibility? What does this prove? I'm sure you will all know that we have to go to Indian Evidence Act and Section 3 of the Indian Evidence Act. I'm an old man, still talking about Indian Evidence Act. What do you call it now? BSA. Don't ask me for the expansion. To manage in court, I have understood BSA. B is Bharatiya, S is Saksha Adhiniyam, right? And you go to one section, the great changes brought about by the new act. You understood, isn't it? Section 3 has been split into 3. 1J, I, and C. Section 3 defined what is proved, what is not proved, and what is disproved. Right? We have now got it. Section 3 changed. 1A, B, C. There you get it. So the question really is, what is the definition of proof? I'll take you to the definition of proof. The next question is, does the statute say that proof in the civil case is different from proof in the criminal case? Does it say that? Does it say that? Obviously not. Proved going by the definition in Section 3 of the Evidence Act and by 1JC and I of your BSA, it all means the same thing, and it means the same thing for civil case and a criminal case. But you will jump at me if I say the proof is the same in both. Because we have been taught, we have been told, we have been used to a system where we think that it is qualitatively different from proof in a criminal case and a civil case are so different. I believe when you question fundamentals only you improve. You have got to question fundamentals. Otherwise we go, beaten track, we'll keep on running like that. You have to question the fundamentals and find out, how is this difference? Is it one of quality or is it one only of a degree? Well, it is there that I think that all of us all functionaries under the criminal justice system must always ask this question to yourself: where does this distinction come from? If that is not permitted by the statute, how are you doing it? How are the courts saying that there are two different standards of proof? Well, it is here that you have to understand the sections clearly. Understanding section 3, I will only say section 3, you translate it to 1ABC. No, I'm not going to. I'm an old man. I have my thing set at section 3. When you go to section 3, I want every judge of facts to learn the definition of proved, disproved, and not proved by heart. That is the Bible, the Magna Carta of a judge of facts. So you have always got to be thorough to understand what these three expressions mean. And I try to recall. Section 3 says, proved, first definition. A fact is said to be proved if a court, after considering the matters before it, not only evidence, matters before it, believes in the existence of that fact. First point, a court believes in the existence of that fact. Or, either this, or considers its existence so probable that a prudent man, apologies to the women, a prudent person ought to proceed under the supposition that it exists. Learn it by heart. Every time you have a factual problem to decide whether a fact is proved or not, remember me and go back to section 3 and say, I will look at it once again to find out what am I supposed to do. How can I hold a fact to be proved and not proved? This is the definition of proved. If you know the definition of proved, the disproved is very easy. Just make some tinkering here and there. A fact is said to be disproved when the court, on the consideration of the matters before it, believes in its non-existence or considers its non-existence so improbable that a prudent person in the given circumstances must act on the supposition that such fact does not exist. Right? I've told you what proved is, I've told you what disproved is. The line is longer than that, there's something in between. What is this? And that is the third definition. When in a situation it does not belong to proved or disproved, you are in the middle. What is that middle? It is not proved. Right? So understand, I wanted a blackboard to draw you. It's okay, doesn't matter. No, don't worry. I'll just say A and B are I'll try to make a geometric presentation on that. Supposing you draw a line, and mark it A and D. A and D. A is the point of absolute certainty. You're no doubt. See, even you want to invent a doubt, it is not there. Like, for example, where an accused admits and he stands by the admission, he confesses and he stands by the confession and he explains every circumstance consistent with his complicity, then you say the fact is proved, absolute certainty, 100% certainty. That is A. In another case, B, where the man proves that he was not there anywhere at all, you are saying that I was there, convincing evidence to show that he was not there. He was sitting with the Chief Justice of India at the relevant time, and he comes and deposes, and therefore you are absolutely certain about the non-existence of that fact. So A to B are the satisfaction that you, on the basis of materials before him, on the basis of matters before him, in the peculiar facts of the case, may come to A, absolute certainty of existence, D, absolute certainty of non-existence. But we don't get cases like that, isn't it? How happy I would have been if when I joined as a direct recruitee session judge, and all these cases one after the other were coming. Then I used to say, if I were to pray to Lord Almighty, I would say, give me a time machine. You have heard of the time machine, H.G. Wells' time machine. You can sit in the machine, pull the lever forward, you go forward in time. You pull the lever backward, you go backward in time. You identify which place you want to go, you go there. I would have asked, dear God, please give me a time machine. If I have that, I need not waste all my time in the court. I'll push the lever and go to the place where the incident occurred. I would look at it, find out what has happened, and give my judgment. We don't have that. We don't have that at all. A judge is to decide on the basis of probabilities. You were not there, you have not seen the incident. If you have seen the incident, you would not be the judge. You will have to recuse yourself, and therefore you can't be the judge. And therefore what happens is, between A and D, at some place the satisfaction rests. Right? Okay, I'll try that. I believe many of you can see that, isn't it? All of you can see that. See, this, on the basis of the matters before it, you may be somewhere between A and D. Where that is, I'll identify now. You could be somewhere between A and D. What the section 3 says is, if you are satisfied about the judge believes in its existence, or if you think a reasonably prudent man, woman or person should have acted on the supposition that it exists, that is proved. Well, I will draw the line here. And say that is B. If you are somewhere between A and B, you can say the fact is proved. Now we go to the other extent. You are fairly satisfied that the non-existence of that fact. And therefore you go to the other end. Mark the point C. Mark the point C. So AB is proved, CD is disproved, and between B and C, what is it? It is again not proved. Understand that. It is again not proved. Only if you are coming within AB, you will satisfy the definition of proof. Otherwise, it will either be disproved or it will be not proved. So we are primarily concerned whether in a civil case or a criminal case with the length AB. The burden of proof by the test of possibilities or probabilities as against proof beyond reasonable doubt rests in the small window of AB. Right? Otherwise you're out of this altogether. Now when you come to AB, I would want you to see how does the distinction between proof in a criminal case and proof in a civil case arise. I've told you already that the definition has to be followed. I don't think you can have any doubt about it. The definition has to be followed. Whatever may have been the common law, or the Anglo-Saxon law, or what we followed prior to the Constitution, all that may help us to understand the present statutory provision. You cannot dispense with the statutory provision, be it Section 3 or 1B, ABC or the new Act. You cannot get out of that. So that the point is, how do you find out? Now I want you to again look at the definition in Section 3 of prudent. It says, when a prudent person, prudent man, it says, it's a very chauvinistic society, where a prudent person, on the basis of the totality of material before it, in the facts of the peculiar case, must proceed on the supposition that it exists. Prudent person standards are woven into the definition under Section 3. Right? Understand that. It's not a one-point definition. The definition incorporates within itself, or the distinction inheres in the definition itself. Because it says that what is the test? What would a prudent person do? A judge either believes it, or somebody asks, is not a judge a prudent person? By the two limbs of the definition. Well, that's a totally different topic. I have referred to it. If that was what was intended, it need only have said, judge on the materials before it thinks that an ordinary prudent person would. So the prudent person standards are woven into Section 3, and that is the crucial distinction as to how a difference in interpretation comes when it comes to a civil case and a criminal case, according to me. What does a prudent person insist? The degree of proof that I insist as a prudent person is always related to the consequence that ensures. You all must be parents or grandparents. When your child does something indiscretion, you're not too sure whether the child has done it or not. The first instance, you only chastise him, you advise him, right? You know that you're fairly convinced that he has done it, you may whack him. The degree of, don't whack him, huh? You are likely to end up, Juvenile Justice Act might take you. I'm talking about my time, okay? Yeah, good for you, okay? Okay, so what happens is the punishment dictates to a certain extent or influences a prudent person to a certain extent to come to conclusions, right? What is the consequence of a finding in a criminal court? It either deprives you of your life on the earlier days than that was the order of the day, and otherwise the freedom, liberty. So when it comes to life and liberty, the courts appear to have assumed that a prudent person would insist on higher standards of proof. That is how, according to me, the distinction came between proof in a civil case and a proof in a criminal case. So, though always, right through, James Stephen drafted the code in 1872, from that date onward, the same definition has been applying to both. It is because the Section 3, your 1,000 so-and-so, gives you a laxity, or shall I call it an elasticity, a freedom at the joints to come to insist on a higher degree of proof in a criminal case because of the consequences that are likely to ensue. Not what I say. The great Judge Lord Denning, I don't want to read it here. No, I'll at the end of it, I'll give you a citation which you read. You will get all what I'm trying to tell you. The judge says there is nothing rigid either in a civil proof or a criminal proof in a civil case or a criminal case. The judge goes on to say that the graver the crime, it is axiomatic, the more the caution that the court will employ. Therefore, even in a criminal case, what you may appear to be sufficient in an open and shut case may not be the standard which you may adopt in a more serious crime. So within the criminal, in a criminal case also, there can be different shades of insistence of proof. The learned judge, Justice Denning, in the celebrated decision, Bater versus Bater, you read that. I don't know, I have it, but I don't think, I have no mood to take that to such a big audience. You read it later on. Right? The court says, in a civil case also, even though you say by the test of preponderance of probability you will decide, there also are different standards. If you say that I'm going to hold the defendant guilty of fraud, I would definitely insist on better evidence. You are deciding a civil case between a promissory note case and a case on fraud, where to enter a finding on liability or on a more serious issue like fraud. Honorable Judge Justice Denning says even there we employ different standards of proof. What am I trying to tell you? I'm trying to tell you that a prudent person's standards vary depending upon the consequences. And that is why, even though Section 3 is the same, over the years we have developed a law which says, on the question of, on a civil case, preponderance of probability, in a criminal case, beyond reasonable doubt. Well, we have to understand this. There is no magic behind the doctrine of proof beyond doubt. I think most of my subordinate judges, or even my peers, and then even the judges of the apex court at times, according to me, do not correctly understand this distinction between the proof in a burden of proof in a civil case and a criminal case as justified by Section 3. It is the prudent person standard that you bring in, and a prudent person axiomatically insists on a higher degree of proof depending upon the consequences. And that is why in a criminal case, higher degree of proof is insisted. Well, in a civil case, you may hold that it comes within A and B. But when it comes to a criminal case, probably you may think that the consequence is deprivation of life or liberty. So I will do one thing. I will reduce it close to B, but I will call it B1. Right? So that in a criminal case, I will hold a fact to be proved only if it comes within AB1 and not if it is within BB1. You understand? This is why I thought it will convey to you more clearly what I am trying to advance before you. See, BB1 may be the additional safeguard, safety, security, certainty that you may insist in a criminal case that may not be insisted in a civil case depending upon the consequences. Then the entire AB may be held to be proved in a civil case, but when it comes to a criminal case, you will hold it so only if it comes within AB1. BB1 is a margin which we may give a concession and avoid a finding of guilt which would lead to deprivation of life or liberty. Well, if you understand this, well, according to me, why I took pains, Madam wanted me to choose a subject. I thought I'll choose a subject which is most wrongly understood in the criminal the administration of criminal justice. We all seem to feel that there is a mystic. This concept of proof beyond reasonable doubt is mystic. It is magical. And you expect impossible standards of proof from the prosecution. Well, it is in this context that I wanted to speak to you on this concept of the proof beyond reasonable doubt, so that let our minds be very clear. The brief of the system is to ensure that a message is sent round to the criminal so as to deter him from punishment. To deter him from punishment, your doctrine of let 1,000 persons go scot-free doesn't. He has to go scot-free. Please understand. I am not saying that forget about the reasonable doubt, convict everyone that comes your way. I am not saying that. But I am saying that you must be very reasonable in understanding the concept of reasonable doubt. That's all that I want to say. And to understand that, this might help you. It is not a difference in quality, but it's only a difference in degree. Every judge decides every matter before him on the touchstone of probability, isn't it? How do you know? Witness comes and speaks something. I think witness is probably speaking the truth. Sometimes I think probably is not speaking the truth. So every time that you come to a finding of fact, you are depending upon your sense of probability, your idea of probability. Without probability, I usually say, is the yardstick by which I measure evidence. If I do not have the yardstick of probability, I become helpless. I can't do anything. So always be very clear. In a civil case or a criminal case, you are assessing the question whether a fact is proved on the touchstone of probability, the litmus test of probability, the yardstick of probability. That is what you do in every case. And therefore, understand this and go to your evidence. Well, this is what I wanted to, the message that I want to convey is, please understand what it is all about. I spoke to the Friday group there on the topic, the demystification of reasonable doubt. Well, that is what I think must happen in this country. There appears to be an assumption that there is some mystic relevance in the concept of reasonable doubt. I am accepting that a higher degree of proof may have to be insisted in a criminal case, considering the consequences that are to ensue. But it is only one in degree and not in quality, not in substance. It's only a question of degree. And in trying to eliminate one case on the ground of reasonable doubt, you are only saying that considering the consequences, I think I must insist on better evidence. Considering the consequences of deprivation of life or liberty, I think this evidence does not inspire me. Something more was required. That is all that is there. Well, if we understand this concept clearly, I think you have mastered the law of the reasonable doubt concept. I repeat, there is no mysticism behind it. There is no magic behind it. There is no expectation of the impossible from the prosecution or the complainant. But it's a question of degree. On probabilities, I may have come to a conclusion that in civil case this is sufficient, but considering the consequences as a prudent person, I do insist on better evidence. Right? Well, I think my class is over. I think I have nothing more to tell you than this. This is what I wanted to convey. I will now try to tell you how this law developed. It's interesting. How did this concept come at all? I read an article some time back before I wrote the judgment in which the topic was origin of the reasonable doubt, theological roots in criminal trial. Well, these are days we go to the God for everything, isn't it? Even for the most secular of things, you go to God, judges go to God to find out what the answer is. Sorry, that's not expected of you. We all pray to God. Who doesn't pray to God? Everyone prays to God. And the Constitution permits you to swear in the name of God, so we do not deny God at all. But to ask for answers from the deity would be very, very difficult. That should never happen. You can pray to the deity, give me a proper frame of mind to appreciate the facts before me. But if you look for the answer in the deity, you are running into great, great difficulty. Right? That is what I wanted to tell you. Don't look for answers in the deity. Request the deity for to give me peace of mind, give me harmony, give me solace inside, so that I'll view the problems with the proper frame of mind. That is why. That is what is required. So this article tells me concept of reasonable doubt, proof beyond reasonable doubt, was not a concept which the lawmakers found out to help the accused indictees. No, far from it. That article says, I don't know how far it is correct. It's an English article which says that. One Mr. Whitman has written that thesis. In that he says, earlier days, hanging was the done thing. It was very, very, very common. So the judges and the jurors, those days you had the jurors, they started feeling very uneasy. God has given the gift of life to a person. I, as judge or juror, is taking it away from him. What will God think of me? See, will God on the ultimate date of reckoning say that, who are you to take away a life that I have given? The gift of life which I have given to one person, you have taken away, so you go to hell. Judges were worried about that. Judges and jurors, the last place that I want to go is that place. No, I don't want to go to hell at all. I want to remain in heaven always. So judges were worried. Judges, you don't know what to do. So what do? When you don't have answers, you look to theology for answers. And the theology it seems told them that God will never punish you, provided you are convinced beyond reasonable doubt that the person is guilty. So how interesting, isn't it? The legal concept of benefit of doubt or the proof beyond reasonable doubt arose from theology. That's what the article says. I have my reservation, but that's what it says. So it's a convenient doctrine to ease the conscience of the judges and jurors that if there is evidence beyond doubt, I can impose any punishment on him and the God is not going to question me on the final date of reckoning. See, they say this is what happened. Maybe you accept it or not accept it, it's up to us to do it. I don't accept it. You can make your choice on that. What happens really is, we have entrenched law. What does it say? A fact must be proved, first of all. Then, those days, matters were being decided by the jury. The judge knew is a trained person with trained intuitions. He will not be swayed this way or that way. I hope you should also not be swayed. Your righteous indignation should not get into decision making at all. Your emotional involvement with the victim should not persuade you to forget about the principles of law. Be that as it may, jurors are not trained in law. You know what? India, we don't have the jury trial. We feed all the facts to the jury, and out comes the verdict, guilty or not guilty. Right? This is the juror's function. And therefore, the jurors were not very competent persons. They were men of ordinary prudence, as it is said in the definition of Section 3. The prudent persons of the community were jurors. You feed them the facts, judge would see these facts can go in, these facts cannot go in. So these are facts 1, 2, 3, 4, on which you have to give me a decision, and the judge leaves it to the jury. The jurors were not experienced persons. They were not trained in law. They were ordinary men with lay common sense. They could be swayed. A very, very deterrent murder, a very, very, very diabolic murder, they may not be too much worried about the facts. They may start thinking about the consequences. And therefore, it's very probable that the jurors have to be advised properly. That is why judges in those days, where the jury trial was there in India, as also in the Anglo-Saxon system, they used to give addresses to the jury. And the jury were told, "Oh jury, do not get prejudiced at all. You are bound to look at evidence dispassionately, and you must find out whether the fact is proved or not. You have to enter the satisfaction that with the given input that I am giving you as relevant facts, you have to come to a conclusion as to whether the fact is proved or not." So judges initially used to tell the jury, "Oh jury, be very careful. Do not be swayed. Ensure that the fact is proved." In a criminal trial also, the judges would have addressed them, "Insist that on proper proof." Jury were not very competent persons, you know. They get swayed by this consideration, that consideration, white, black, deterrent, very, very diabolic crime. They get swayed. And when they were getting swayed, judges thought, "No, this is very bad. I should not permit this." So the judges said, "Insist on proof beyond doubt." What does it mean? I told you it's a question of degree, and there was only a warning to the jury, please ensure that there is proof beyond doubt. I'm asking you, between A, B, if a fact lies, there should be no doubt. Well, you have held it to be proved. There is a question of doubt. But then it says, prove beyond doubt. If you want proof beyond doubt, you must have been somewhere here. Can there be a proof with doubt? There cannot be. Therefore, you must have been somewhere here, and that would have been between B and C. It would have been not proved. It was not necessary to address them and say, insist. It was enough if you said, insist on proof, which means you will come within B1 or AB1 or AB. You would have come within that. But because of the lay jury, to avoid mistakes, the judges started addressing them and saying that please insist on proof. One, please insist on proof beyond doubt. According to me, both mean the same thing. No distinction between proof and proof beyond doubt. If it is proved, you will come within AB1. If it is proved, if there is a doubt, you will go outside B1. Right? And therefore, insistence on proof beyond doubt was only a safeguard of the alert judge to ensure that the jury does not flounder. Then the judge found, even after I say this, they are not doing proper things. His conscience is worried, and he has to overrule the jury sometimes. And therefore, he went further and said, please insist on proof beyond reasonable doubt. I always laughed at the idea. If my doubt is not reasonable, will I call it a doubt? Very good. Can you say, I have a doubt, but not a reasonable one at all? Can you say that? Well, my point is not just to make fun of him. What I'm trying to do is, you must understand what this concept means. Right? It's for that I'm straining on this. According to me, proof means it will come within AB1. A judge need not be told repeatedly of this. When I say, you know that it must come within A and B on probabilities, a small window for the criminal case or BB1 exclude, so it must come within AB1. Is it necessary for me to tell you, trained legal persons, insist on proof beyond doubt? Then you laugh at me and say, sir, if I have a doubt, it will be outside B. Why are you telling me this? Then the next one, proof beyond reasonable doubt. And I always laugh at it saying, I have a very, very bad doubt. But it is a very unreasonable one. It's not a very reasonable one. Well, it conveys nothing more than what you have initially said of proof beyond doubt. And thereafter, some judges, while they addressed the jury, made it more rigorous and said, prove beyond the shadow of a doubt. Indian law has given it up. There's no shadow of doubt, either in India or in the Anglo-Saxon. But they went to that extent to say, prove beyond the shadow of a reasonable doubt. If there is a doubt, it is not proved. If there is an unreasonable doubt, it doesn't affect you at all. If there is no doubt or a reasonable doubt, there will be no shadow of a reasonable doubt. What I want you to understand is, all these were attempts to ensure that you don't get swayed when you come to a decision that you are within AB1. That was the purpose, which I certainly want you to understand. I want you not only understand here, it must get deep down into you. Tomorrow when you go down to appreciate evidence in a criminal case, you have to understand the definition proved. You have to understand that there is no distinction between proved and a civil case. The margin is only because of the consequences, and then proof is sufficient. Proof beyond doubt is only proof. Proof beyond reasonable doubt is only proof. Proof beyond the shadow of a reasonable doubt is also proof. Right? That is it. That is the next one that I wanted to, how this, because when I take classes, young judges ask me, what are you telling me? Read this decision, read that decision, everywhere it is said, if there is a doubt, I'll take it outside AB1. If there is a reasonable doubt, it will be far away. See, you will hold like that. Once you know the mechanics as to how this concept has emerged, that is why I've taken pains to do it. I want you to see, it's very difficult to advocate one's own decisions. But whatever I have said today, you will find reflected in 2 judgments written by me at the Kerala High Court. If you have the time or the inclination, please go through it, because I think the short time that is available, I have not been able to take you through the entire gamut. If you are interested, if you think why this person is saying all this, to understand it better, if you have any doubt, please go through 2 decisions of the Kerala High Court, where I headed the division bench and I held so for your convenience. Only to amplify what I said, because of want of time I have not been able to. They are Jose versus State, 2010 SCC, online, Kerala 346. I have asked your director to give you copies of that judgment if possible. 2010 SCC, online, Kerala 340. Not because it's a wonderful judgment, but because to understand what I have said today, it may help you. Only for that purpose I am giving you. And the next one following that is Krishna versus State, 2012 SCC, online, Kerala 31617. Krishna versus State, 2012 SCC, online 31617. Your director has promised to get you copies of that. If you are interested, please read that, so that if you think, why is he saying this? Or another aspect, I think I have considered everything possible there. You will get to know why I am advocating what I am telling you now. There is one more decision of the Supreme Court that I wanted you to see. I was not there in that case. Govardhan versus State of Chhattisgarh, 2025 SCC, online 69. I have marked the relevant paragraphs also, and given the list of judgments. You can, if you are interested, if you think I have provoked you sufficiently to go further into the matter, please go through those decisions and some other decisions also. I am passing on to them. The relevant paragraphs are also numbered, so that I don't think in a big hall like this I can take you through the nuances of each decision. I am not trying to do that. I'll just take another 5 minutes to complete the discussions with you. I find the criminal justice system faces 2 primary challenges. These are all in details, how you do things. We have 2 fundamental challenges to the system. One, I would say, is that we do not have a credible police force. We live on a regular diet of distrust against the police. Why do we do so? I'm not saying judges are not justified in doing that, because even after about 80 years of independence, we have not been able to develop a credible police force to aid the court in the administration of criminal justice. You know Prakash Singh, so many decisions have been rendered, but still we find that we are sadly, badly lacking a credible investigating machinery. Parrot in the cage is the expression that a court used for a very reputed agency. Then some of them are worse than that. And therefore, it's important that as functionaries in the system, we must clamor for a more credible police force. A credible police force will not descend from the heaven. You have to trust them in order to get responsibility. If I do not trust my junior, if I do not trust my staff, he will never be responsible. You have to trust them, so that look at the plight of the Indian police force. The American trusts Bobby. The Englishman trusts cop. Strangely in India, we continue under the imperial relic of not trusting our police, and we think it's a great matter to do that. And therefore the police also would think there's no point in being responsible. There's no point in being credible. Nobody is going to believe us. Well, would you know that both in England and in the US, statement of an accused can be recorded after administering the oath. But in my India, after 80 years of independence, I will not permit the police officer to take a signature in a 161 statement. Well, you want them to be responsible, but you don't give them the opportunity to be responsible. Please understand, I've been in the system for the last 55 years. I am not advocating that the police can be trusted straight away. But the attempt to create a credible police force must start at least now. Well, if you have a law like every statement recorded under 161 must be placed before the court within 24 hours, or say 48 hours, it would enhance the credibility of a 161 statement overnight. Because the judge will have it. And the policeman will also not be prompted by a yen to create false evidence. I would time at my disposal limited. This can be a topic for further discussion of police reform that ought to come in. And I think Republic of India, independent India, must develop a democratic police force which is credible, which is truth-searching, which is unbiased, and which will aid the justice system. Today we don't have that. And that is one of the great difficulties that every criminal justice adjudicator is facing. Just one more point and I'm done. I have a family meet to attend. If I'm not there, I might get divorced, and therefore I have to go immediately. The next new challenge is the media trial. Judges today are afraid. I know High Court judges who do not grant, I know session judges who do not grant bail in any matter. Why? If they grant bail, their motives are suspected. Justice Chandrachud in one decision very clearly said, don't suspect any of them. Right or wrong, the judgment should give, the order must give the reasons. Right? And therefore today media trial is such that judges, functionaries at all levels, including the Supreme Court, with due respects, I may say, the type of questions that sometimes come from the bench is shocking, exasperating. You are worried about tomorrow's headlines. I'm sorry to say this, but judges as a class are sometimes, this has been always there, but today because of the, social media, etc., the problem is getting more and more compounded. Judges must be made of sterner stuff. You must always have the feeling that I'm answerable to my conscience and the law. I am not answerable to the print media or the social media. I am my own master. I would even say I am not even answerable to my portfolio judge when it comes to matters of decision. I'm sure your portfolio judge will not interfere, but I know some of the states where as soon as a man writes a bail order, he is asked for explanation. Well, I want you to understand that we all read that Shetty Commission report, All India Judges case. Each judge from the magistrate level to the Lord Chief Justice level, you are exercising incidents of sovereignty. You are sovereign in your domain. You are not answerable to anyone except your own conscience and the law. Don't say my conscience tells me this, whatever the law. Your conscience and the law. You are answerable to both. I know some of the judges who say, as soon as PW1 gets into the box and deposes something, he says, I know the truth. No worries at all. I know the truth. Now, I don't want you to be that sort of a conscience judge. Now, subject to your conscience and the law. Both are important, right? Well, try to learn to keep away from such media influences. When Kasab was hanged, that was one of the days when I hanged my head down in shame. When Kasab was ordered to be hanged, you know, we all had righteous indignation against him. He had killed so many people. But there was also on the other side a 16-year-old boy who was swayed by misplaced idealism or to do that, all that. That's not important. But what happened was, on that morning, all the channels were running a show. How many people are in favor of death sentence? How many people are in favor of life sentence? And they found 0.00001% only for life sentence, every other person for death sentence. The judge who is writing the judgment should not be influenced. He must be made of sterner stuff, but he is also a human being. He is also a human being. I want you to be extra human beings when it comes to matters like this, and stand your ground with your conscience and say, I will decide what I think is right, true to my conscience and the law. I keep repeating, conscience immediately tells you and the law, because otherwise I find it very difficult. Conscience and the law, you have to do that. Well, I would think these are two things: a credible police force on whom we can trust, and freedom from the glare of adverse media. May I call it uninformed media? Uninformed media. They know nothing. They know nothing. Some of my judgments are discussed before I sign the fair copy. You can understand how they do it. I write a judgment and I say, what is the satisfaction which every judge should have? What is the satisfaction that you should have? At the time when I called the stenographer and started dictation and closed it, I am conscientiously convinced that I am right. Right? You can't have any better satisfaction than that. Every judge writing an order should have the satisfaction with the lights that I have. A superior judge may having better lights, he may decide it. With the lights that I have, when I analyze the facts in the law, this is my conclusion and my reasons are here in the judgment. You accept it or not accept it, it's your worry. You criticize the judgment, I have no worry. Even if you criticize me, I have no worry, you do it. Right? But the point is, you must have the strength of character to be convinced that I am deciding according to my lights, properly, honestly, bona fide, true to truth and justice. That is the satisfaction that you should have. Once you have that satisfaction, don't worry about what the whole world says. Forget about it. I can tell you, I've been at the receiving end of this sort of criticism. I always enrich myself with the thought that I want to be a good, firm judge who's true to his conscience and wrote what he did. Later on, another judge may find. Some judges say, my judgment has not been reversed by any high court. You must have seen such people. Some of them say, my judgment has not been reversed by any high court or any Supreme Court. Being identically foolish is no guarantee, isn't it? No, but I have heard very important judges clamoring that my judgments have not been reversed. Well, small minds, forget about that. I don't want you to fall into that trap. That's why I'm giving it to you, right? Okay, these two things you bear in mind. Finally, before I close, let me offer the most sincere felicitations to the Karnataka Judicial Academy. I know, I have come to know that your Judicial Academy is engaged in the sublime task of molding ideal judges. Well, that should give you all the satisfaction that it requires. I would think that imparting a lot of information is not the function of the Judicial Academy at all. You can read judgments. You all have written competitive tests, you have qualified, you belong to the elite section of the bar, you have come here, and therefore I'm sure you can read judgments and understand. Sometimes there is the difficulty, you may be aided, you may be assisted. Bar will assist you, or the articles will assist you, but don't worry about that. Creation of the proper mindset in the judges is the real challenging task of the academy. I want judges with the right mindset. It's very important that the judges have the right mindset to address the task which they are called upon to. The country trusts you. The country looks up to you. Whom? Not only the judges of the Supreme Court and the High Court. The country looks up to ordinary judges whom they every day interact. You maintain a high standard of behavior and quality, the polity respects you. The honor which the judiciary today has is not because of the erudition of judges of the constitutional courts. It is because of the sacrifice, commitment, and dedication of ordinary mortals who work at the grassroots level. I want each one of you to understand that that is your brief. Well, I keep repeating a story many, many times. A great Chief Justice came to my district and gave a speech, and then I keep repeating it. I repeat it so many times that my juniors, my wife, etc. say, if you're going to repeat the story, I'm not coming for the function. But that has impressed me so much that I want young people to know about it, and therefore it's a parable-like story. 3 persons were cutting stones, right? Standing in the very hot sun, all the 3 were cutting stones. One man saw all the 3 cutting stones, and then he had a mischievous intent. So he went to the first man and asked him, "What are you doing?" Man got wild. "I am standing in the hot sun and cutting stones. I don't have time to walk around and ask silly questions like you. I am standing in the hot sun and cutting stones. Can't you see that?" He went to the second man, doing the same job. Asked him, "What are you doing?" He said, "You have nobody waiting for you at home. I have to work and earn a livelihood. If I don't work and earn a livelihood, they are going to starve. I have that responsibility. And therefore, please understand that I am putting in efforts, standing in the hot sun, cutting stones, so that I can support my dear and near ones." Very correct. Both of them very correct. No, nothing wrong in the answer. He went to the third person and asked him, "What are you doing?" And the third person said, serenely he said, "I am building a cathedral. I am building a cathedral." How many among us work to dispose of cases, to earn livelihood? How many of us work with the concept that I have been given an opportunity to build a cathedral of truth and justice? Well, can you have that attitude? I wish your Judicial Academy instills in you that frame of mind. Thank you very much. It has been a very pleasure.
The ceremonial vote of thanks will be said, but I cannot stop myself from saying this. Thank you so much, sir, on behalf of everyone present here. Thank you.
Thank you, Your Lordship, for the enlightening lecture. Your insights into the doctrine of proof beyond reasonable doubt have deepened our understanding of the concept. Honorable Justice